It's Wells Fargo or Wachovia, but it says their dilemma is they hate to love niggers and love to hate niggers.
Hello and welcome to another edition of the Courtroom of Public Opinion. My name is John Singletary, and today this is just a short, brief video to let you know that in the situation with Wells Fargo says Wells Fargo loves to hate niggers and hate to love niggers. Of course, I spoke with the head of the communications for the NAACP, Mr. Derek Turner, who has refused to not only return my call, but to make any type of statement regarding Wells Fargo. I spoke with the secretary for Mr. Holdeman for Magic Johnson Enterprises, who has also refused to not only return the call, but to make a statement. Now, when is enough enough? All across the country, whether it be with the Ms. Birnbaum, Ellen Birnbaum case, people are standing up saying enough is enough, and that apologies are accepted, but they do not negate the fact that there has to be consequences. There has to be consequences for the actions. You can't do something, just apologize and say, hey, it didn't happen, because the effects of what you did are far-reaching. Wells Fargo, for instance, their effects are generational. When I say generational, consider this. Many African Americans, their home, their dream home, is what allows generations to go to college. Parents take out of that home the equity and send students to college. And then that student is in a much better place when it comes to their capacity to earn. College education puts considerably more into your life funding stream than not going to college. And as a result, for many of us, that is the conduit in which we rise to a different level. As a result, it is clear that when Wells Fargo comes in and does illegal foreclosures, foreclosures that have made everyone, or some people, commit suicide, that has made some people die in the courtroom. Those kinds of things must be dealt with and cannot be continually tolerated in our society. Now back to the generational issue. When one generation is denied the right to move forward through education, then the next generation suffers, and the next generation suffers. And so when Wells Fargo comes in to do the illegal foreclosures, and when Wells Fargo comes in, applies a racial surtax to get more, to steal more in closing costs and in interest rates against the law, and then they come back after taking billions and spread a few millions around, that should not be allowed to be a down payment or payment for us not dealing with Wells Fargo. No one wants to stand out and make a statement that Wells Fargo's statements of Wells Fargo loves to hate niggers and hates to love niggers is not only vitriolic, but it's damaging to our community from a generational standpoint. Enough is enough. Wells Fargo must be dealt with. Not later. Today, right now. If you have money in Wells Fargo's bank, you should remove it. If you're dealing with someone that uses Wells Fargo, then you should impress upon them that, hey, if I am to continually do business with you, then you have to use another bank. And it's as simple as this. If you give tacit endorsement to it by staying silent and allowing it to continue, allowing your money to be placed in Wells Fargo's bank, then you are encouraging and supporting that type of behavior. There has to be a concerted effort from the public as well as the government to deal with it. President Barack Obama made a statement concerning the Donald Sterling situation. he needs to make one concerning Wells Fargo. There needs to be a full investigation by the Department of Justice as to Wells Fargo and the Singletary case. John and Carla Singletary were not behind on their note. What happened was Wells Fargo, in the interest of North Charleston, decided that they would come in and do an illegal foreclosure by giving back their payments. So they sent the Wells Fargo check to give John and Carla their payments back. Then Wells Fargo refused to take any more payments. Then they used Provest, who has been in a lawsuit or investigation situation in Florida and recently settled out for close to $500,000 for what they call sewer service. Sewer service is the process in which, rather than give the defendant the summons and complaint, they throw it in the sewer or somewhere else. Wells Fargo then goes into the court system, says, well, they won't respond. The judge gives them then a order allowing them to foreclose on the home. When all the while, John and Carla, or the defendant in any other case, is not even aware that a foreclosure is happening. When they contact you after they get the order to let you know when the date of the sale is going to happen. When the date of the sale is going to happen. Not allow you to come into court and defend yourself. Now, not only is that wrong, but that places the homeowner in the position that, in violation of the Sixth Amendment, that their home is being taken without due process of law, which is illegal. It is wrong. But that's what we're dealing with, and the kinds of skullduggery that Wells Fargo engages in order to steal homes. The whole purpose behind this one was so that the friend of Wells Fargo, Mayor Keith Summey of North Charleston, who has admitted to racial statements in this case as well, is able to be shielded because he has done the wrong thing, and we'll be giving you great details about that situation. But so that they can shield them in terms of their liability by removing the home from the Singletaries, hoping to remove the standing to sue. If there's no standing to sue, then there can be no case. And so that's the whole purpose behind Wells Fargo getting involved in this situation and illegally attempting a foreclosure through Judge Mikhail Scarborough, who has admitted to violating the law. Wells Fargo recently admitted in federal court that they practiced without a license in closing the loan of the Singletaries, which gives them, it bars them from any remedy within the court system, according to the South Carolina Supreme Court. However, in this case that deals with an African American, they're not addressing that. Even after they have admitted there were two loans. They've admitted that they have, on the loan, that they have practiced law without a license in the state of South Carolina. However, Judge Mikhail Scarborough allows them to come to him with unclean hands, and he gives them a remedy in the court system contrary to the previous rulings of the South Carolina State Supreme Court. Wells Fargo attempted to convert a construction loan to a permanent loan without the use of an attorney. Yet they go to the system and ask for a remedy and is given the remedy. These are the kinds of systemic and foundational injustices or injustice that I am talking about when I say that until we get the justice system straight, then the rights that are given in the Constitution that are guaranteed are violated with impunity. The decisions are repugnant to the Constitution, and as a result, we will never move forward. When you can ignore the Sixth Amendment that a home can be taken without due process of law, and no one says anything, and the statements that are made. Mayor Keith Summy admits that he is well aware and knows who made the statement that was placed in the Post and Courier that said, who does that black man think he is, building a home like that in North Charleston? We've got Judge Marchand on the case, who belongs to the invidiously discriminating organization called Forest Lake Country Club, with the white members only in the deed in the courthouse. We've got North Charleston saying that the South Carolina Supreme Court gives them the right to enforce and the authority to enforce racially restrictive covenants. And we have Wells Fargo that says Wells Fargo loves to hate niggers and hate to love niggers. And no one is saying anything. This is a situation that calls for a Department of Justice investigation. And we're asking that you come down. Attorney General Eric Holder, you were just here. You were here for the unveiling of the Waring statue. Now, in unveiling the statue that is above ground, we all know that Reverend Delaney is the individual who started the whole movement for the Briggs versus Elliott that was foundational for the separate cannot be equal. And he is not allowed to even be brought down back to the state and buried underground as a black man in the soil that he grew up in. You came for the unveiling. We need you back. We need you back in South Carolina to investigate this case, Wells Fargo versus Singletary, and the injustices that are occurring wholesale from the state judges all the way through the federal judges. Come back to South Carolina. We need you to take a look at this situation. Now, in addition to the unveiling, here it is, Reverend Delaney. The warrant that would not be removed was for not that he was shooting against someone, but because he was defending himself and shooting back at someone who was shooting at him. So the concept is this, that they will pursue you until you stand up for your rights. And when you stand up for your rights, now that is a show of aggression on your part, simply because you choose to stand up, in his case, to defend your life. And so I guess they thought that he should just lay down and allow them to kill him. In this situation, it's no different. They expect me to lie down and allow my rights to be trampled on without doing anything. And the second I go to fight back, now a network of good old boys in a good old boy system chooses to come in and decide collectively they're going to take all of my constitutional rights to due process and equal protection. I guess that's why the 1979 article in the Crisis of Conscience, when they talked about the judges in the South and how many judges, over 90% of them, were involved in invidiously discriminating organizations, and how Judge Ballou out of Texas said that, well, the question there about the niggers never came up. And Congress, the Congressional Committee, affirmed him. They confirmed him as a judge, even though the record bears that he made those statements. We can't do anything about the past, but certainly they could stand up now. Certainly they could stand up now, because to not stand up means they're giving tacit endorsement to the very same thing that they did in the past. That's atrocious, and it needs to be dealt with. Now, we can move on and talk about Judge Weston C. Houck, who was also confirmed at the same time, also belonged to invidiously discriminating organizations, and the Nucor case. The Nucor case that has been riddled with judicial abuse for over 15 years now. They've been like a hamster on a wheel, running around and around and around. And Nucor makes statements that, well, they refer to employees, African American employees, as DAN. Now, DAN is an acronym that's used at Nucor for dumbass nigger. DAN means dumbass nigger. Now, there are some that they would call that and some that they wouldn't, but they refer to all of them in the back rooms as that. And of course, the deposition bears that out. That case in South Carolina has gone nowhere because Nucor spreads money around. Nucor has put up billboards that say that African Americans are being promoted. Well, there are absolutely none whatsoever, no plant managers in Nucor Steel that are African American anywhere. In fact, there are no contributing managers at the time of the filing of that lawsuit in Nucor anywhere. Individual contributor, there might have been one. But in terms of individual contributing manager, many African American employees, and I can say that because I used to work for Nucor Steel. I can say that because Nucor deposed me in that case. I can say that because I was at Nucor and experienced and saw with my own eyes some of the racial insensitivities that were there. And so, when I say that the Nucor case is being, in South Carolina, cut off at the knees, I know what I'm talking about. The Department of Justice needs to come in and take a look at that situation as well. How can Nucor continually be allowed to be involved in government contracts, federal government contracts, state government contracts, municipal government contracts, when they are showing not only discrimination in employment, but also discrimination when it comes to the types of environment that they set for employees? That kind of thing has to stop, and there has to be a stand from the government that, hey, listen, not only do you need to settle those cases out for the wrong that you've done, but in addition, you need to be banned from government contracts. But when we have a judicial system that denies you the right to a jury trial, how can in 15 years a case not be brought to court? Well, when the judge starts off by saying, well, I never thought it should have been a class action case from the start, and he refuses to listen to the appellate court judge's order to certify the class. And he decides, well, I'm going to wait for a year before I do it. And then after he does it, he decides that he's going to decertify the class. And I can go on and on and on about that case. But the point is this, that in South Carolina, justice is being denied. And part of the reason why we have the 1983 Act that was originally named the Ku Klux Klan Act. Part of the reason is because when we are denied justice in the state court, the federal court is supposed to be our guardian. We're supposed to be able to move over into the federal court and get some justice. What we found is that we've moved over from a situation where there is no justice to a situation where there will never be any justice if something's not done. And so the federal court is getting worse than the state court, and the federal court is supposed to be the protection for us as a people when we go from the state court to the federal court. That is being denied. We'll talk more about denial of due process, equal protection, and the fundamental fairness on the next video.